Thank you all for joining us again. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Today we are going to be talking all about nuisances. I have Cynthia Jones and Adam Bowden with us. Some people like to say Adam Bowdoin, and is not French, but maybe it is. So all about nuisances. As a reminder, we do record these presentations, and we do hope that you will share the information that you learned today with your other board members. So the recordings can be found on our brand new website at camsmgt.com under the board members section. So I did mention it's a brand new website, so hope you will explore the camsmgt.com website. It's lots of new great features. Tried to make everything a little more navigable for all of our users. So please take a look and let us know about the new look. So Cynthia, Adam, I will turn it over to you as we try to start sharing that website. Cynthia, I don't know if you've gotten the email, but hopefully we can get it loaded. And if you need me to, let me know if I need to work on it. Oh, as a reminder, with questions, if you do have questions, please use the Q&A feature at the bottom of the page. Type those questions in and I will read the questions for Cynthia and Adam to answer at the end of the presentation. So looks like we're ready to go. Cynthia, Adam, turn it over to you.
Thanks, Ben, and we really appreciate the opportunity for CAMS to give us this platform. I'm Adam Bowden, Cynthia Jones, my partner in crime today. We're going to be identifying, avoiding, and navigating community nuisances, a topic that is near and dear to all community association lawyers' hearts. And so there's going to be questions. Ben and Rudy are monitoring those and we'll answer those at the end. We promise to keep it moving. And so without further ado, Cynthia, why don't you tell everybody out there in virtual land what is a nuisance?
And before you get started, I'll just mention, I noticed the title of your presentation. I know this was just given at the North Carolina Law Day, but I want to make sure we do touch on South Carolina as well. So probably some South Carolina topics to hit. So, but it said North Carolina there. So just, okay, back to you.
Absolutely. Well, thank you, Ben. Thanks for having us. We will hope you enjoy your next hour talking about nuisances. I know that I dealt with this exact scenario today. So we deal with it all the time. What is a nuisance? So there's a couple different kinds of nuisances, public nuisances and private nuisances. For purposes of this presentation, we are only talking about the private nuisances that exist. And so a private nuisance is defined as a substantial and unreasonable interference with the use and enjoyment of the real property of another. So at a baseline, anybody can use their property in any way they want, as long as that use does not unreasonably injure or harm someone else's use or the enjoyment of their property. So we start with the baseline of you can do what you want with your property, subject to the covenants and restrictions on it, of course. But as long as you don't unreasonably interfere with someone else's enjoyment of their property, that should be fine. And so there's lots actually in these definitions. So we're going to talk about a couple of these terms and what they mean. Okay. So substantial. So we talked about that had to be a substantial interference. So what does that mean? It's not going to be something that's just annoying or problematic or that you don't like. It has to be something significant. It has to be a material discomfort, an injury to a person's health or property. If there's a really strong odor on the property and you can't get away from it and you can smell it from your property, that could be significant. But it's got to be something more than just, I don't like it or it's annoying to me. So substantial is the key word there. It has to be unreasonable. So if an ordinary person, and as lawyers, we have this all the time in law school. If an ordinary person with their discretion, would consider it excessive or inappropriate after you give due consideration to the interest of the person that's doing the offending and the community. Is it unreasonable? So it can't just be Cynthia thinks it's unreasonable or Adam thinks it's unreasonable. You have to look at it from the ordinary, a person of ordinary prudence and discretion. Would someone like that consider the use to be unreasonable? And if so, then it might fall into this category of a private nuisance. In North Carolina and in South Carolina, thank you, Ben, the courts use a balancing test to determine if the interference is unreasonable. So they're going to weigh the harm that exists and the utility of the conduct to see whether or not something is reasonable or unreasonable. They're going to give a balancing test. So they're going to look at both sides of it. Is the use of the property outweighed by the harm that it causes? So these are some factors that courts are going to consider for a balancing test. And I'm just going to go through this list and you're going to kind of see some of the things that the courts look at when they're determining whether or not there is a private nuisance that's actionable on the property. So the surroundings and conditions under which the offending party interference occurs. What's happening around the property? Is it something that's pretty normal in that area, or is it something that's unusual? The character of the location. Residential location is going to be a little bit different than some sort of commercial location, and you're going to be able to do some different things on that property. The nature, utility, and social value of the offending party's operation. Is it a huge value or just something they get some benefit from? The nature, utility, and social value of the offended party's use and enjoyment that has been invaded. The suitability of the location for the operation. The suitability of the location for the offended party's use. The extent, nature, and frequency of harm to the offended party. The priority and time of occupation or conflicting uses between the parties. And then they can also look at any other factors. But these kind of show you the process and the thought process that goes into it when there's litigation over nuisances and the balancing test that is weighed between the person who's complaining and the person who's making use of their property that's being complained of. And the courts look at both factors, and they look at a lot of other things that we're going to talk about today too, but these are some of the big ones and that need to be looked at in determining whether or not there's a private nuisance that is actually taking place.
Yeah, and as Cynthia pointed out, and this balancing test holds true for North Carolina and South Carolina. And the cases that we looked at in both North and South Carolina dealing with a private nuisance, shockingly, most of them deal with shooting ranges, racetracks, and dog kennels. Those are kind of the hot button issues. Now, you go out to the Midwest, and it'll be hog farms or cattle ranches or goat farms, any place where you're going to have odors and sounds and things like that. So when we talk in the community association context, right, what are the most common types of private nuisances? There can be others. As Cynthia just pointed out in the last slide, courts leave that loophole open in terms of any other reasons, right, any other factors. Now, I will tell you that both North and South Carolina stand for the proposition for the free and fair use of your property, right? The balancing test in North and South Carolina is going to give more weight to you using your property the way you want to at baseline. Of course, once you move into a planned community, as we march ourselves, right, you're giving up some of your rights when you're in a planned community that you might have outside of that community. So the most common types of private nuisances are going to deal with sound, with smell, and with sight. So let's kind of look at each of those in turn here. So sound. Noises that are loud, obviously, right? Audible, that are happening on a regular basis for a long period of time or in odd hours, right? Some people love dogs, guilty as charged. Some people hate dogs. But the one constant with all dogs is they bark. Every single dog, whether it's 5 pounds or 150 pounds, is going to bark. So at baseline, a barking dog is not a nuisance. But if you have 5 barking dogs that bark for 8 hours straight and they're all 100 pounds each, that might be a nuisance. But if it's a 10-pound dog that barks for an hour every day around lunchtime begging from its owner, that's not going to be a nuisance, okay? Loud music, parties, obviously. Parties have that combination of loud music and loud voices. Maybe there's a band, maybe there's live music. We talked about racetracks. We talked about shooting ranges, okay? The one thing that's very congruent, though, both in North and South Carolina, is that if the shooting range already existed or the racetrack already existed and you bought property near it, that's on you. You can't say that's a nuisance now. And racetracks, interestingly enough, also, in addition to sound, can be a light nuisance as well, especially if there's night races where they have big bright lights shining all night and hooting and hollering. So sound is a big one, especially we see it in multifamily, where you have maybe some folks that like to go to bed early and there's folks that like to party all night. These are times when you might, have some neighbors butting heads. So go ahead, Cynthia.
Going to say, I think a lot of these categories of nuisance that we're talking about, I mean, in multifamily properties in a condominium, these are very prevalent because you're living in such close quarters to somebody else.
That's right. Townhomes, condominiums, that's where we see the largest number of nuisance complaints. And most of those relate to smell. And so in close quarters, now that you can smoke some hemp, some Delta 9 if you want, right? There's a lot of vaping, there's a lot less cigarette smoking, but could that be a nuisance? Pet waste, unbelievably, we've found some cases, not in North or South Carolina, but some cases in other states where there were common areas where owners refused to, I guess, pick up the pet waste, and it built up so much that the next door neighbors were getting the terrible smell of decaying dog feces. And so that can happen, right? Cooking odors. Cooking odors is a big one too. Cynthia and I, when we looked at this, a lot of different cultures use different spices, different cooking techniques. And you got to remember that the Fair Housing Act does protect national origin. And so if your neighbor is cooking up a lot of spicy food and you don't like the smell of it, that may not be a nuisance, or it may be protected based on culture, right, under the Fair Housing Act. So you got to be careful. And then septic systems. When I lived in Trent Woods, North Carolina, I had a septic system for the first time. I didn't know what that was. I came from New York State. I was like, oh, it's a sewer. They're like, no, it's your own private sewer in your backyard. It leaches out. And I remember when a landscaper accidentally went over it and knocked a hole in it, right? Then I knew what a septic system was, and so did my 3 other neighbors. That was horrible, okay? And so anyhow, these are things people leaving their garbage out, right? The smell is one thing, but it also can attract varmints, right? It can attract rodents, trash bandits, those little raccoons. So those types of things could also be a nuisance. And finally, our third one here is sight. Most of the time when we were looking at sight nuisances, they were also included sound with them. generally. But there are some cases that we found, not in North or South Carolina, that where people would shine in a townhome community, shine floodlights into their neighbors' bedrooms and stuff, just because they didn't like them. And yeah, that's nuisance behavior. One of the questions that folks have asked us about it, neighbors is, well, what about a large tree, my neighbor's tree that's hanging over, that's a nuisance because it's giving me anxiety? Well, not really, okay? If it's dead, dying, or diseased, right, which has a good chance of making it fall, then maybe. But that's not really a nuisance. It's more of a trespass because it's a physical presence, right? And so another thing that we've seen is this landscaping, or what we call no-scaping, where folks get approval where they just have a full rock front yard with cacti and maybe some predator plants. And the other neighbors don't like it. They think it's an eyesore. We have seen cases like that. Excessive junk and clutter. I had a case recently where a guy had a sculpture of a giant T-Rex and some other dinosaurs. He said it was artwork. He would have the T-Rex, which was like 12 feet tall, by the way, jumping out of bushes to attack a family of triceratops who were 8 or 9 feet tall. That person probably is an interesting person and someone that you might want to talk to, but you don't want them in a planned community. And so that we found a community nuisance in that regard and got rid of those metal and concrete dinosaurs. And the gentleman has moved to a piece of property where he can do whatever he wants. And now he has a full Jurassic Park on his hands.
Well, and I will say too, I've seen a lot of the site nuisances when neighbors in a community start to disagree about things and they want to maybe get back at their neighbor. And so what do? They play loud music. They put up a motion light that projects onto the neighbor's property. So anytime there's any movement, the light shines right into the neighbor's house. So be aware of that. I mean, it happens. Adam and I can tell you, it happens very frequently. We get calls about these kinds of things all the time. And the question just is an evaluation of that balancing test. And is there enough here to actually call this a private nuisance? If there is, then the next question is, what can we do about it? And how do courts deal with it? If we were to take it to a judge or a jury, what would happen? So there's a couple different options here that are available. One thing the courts can do is give money damages, try to compensate the person who has been harmed or who is being harmed by giving them money from the person who's doing the harming. That is an option in a private nuisance case. More commonly probably is an injunction, which is an order from the court, which tells the person who is making the offending use of their property to stop whatever that action is. So if it's shining the motion light on your neighbor's property, the court can order them to take that down and stop that activity. They could order the stopping of races on the racetrack if it is too much of a nuisance. Those kinds of things are injunctions where the court tells someone you can't do this anymore with your property or put some restrictions around when they can do it. And also the option of recovering costs and fees, attorneys' costs and fees for having to bring the action can also be included in a private nuisance action when you're taking action for something that's happening on private property. So those are all options that are available. The court can do any one of those. You know, Adam and I know frequently judges will do what they want to do. So it just depends on the certain situation and the certain circumstances surrounding the nuisance in any given case as to what the judge might do with that.
And let me jump in just real quick. On the injunction, the beauty of the injunction is it's basically a court order, okay? It's the judge saying, you can't play your music, or you can't have your lights, or you can't have a full-on hog pit in your backyard. And if they violate it, what has happened is they're now in contempt of court, which means that they could suffer additional civil penalties monetarily, but it means they can also go to jail. That's the biggest sledgehammer that you've got, right? Most of the time, when you have a private nuisance, the person just wants the behavior to stop, right? And that's the injunction. Now, they're not inexpensive, are they, Cynthia?
Oh,
Hey, kids got to go to college. Let's go.
very expensive. All right, so you're in the planned community context. We have some sort of nuisance going on, or we think we may have a nuisance going on. What are the kinds of things in a planned community that might give rise to a nuisance claim? So we broke this down into two categories just to kind of make this easy. One is the activities that people do on the common areas or the amenities in the community, the ones that are owned by the association. So what's happening on the playground or at the pool or in the clubhouse throughout the community, things that the association can control. And then the second category is what's happening on the owner's private property. So whether you're in a condominium community, a townhome community, single family community, what's happening? What are you doing with your property that may be causing a nuisance to a neighbor? And then we'll talk a little bit about when the association needs to get involved in those kinds of nuisance claims, because there's times when the association may need to get involved with those. We can't say any longer, oh, that's just a neighbor to neighbor issue, and stay out of it. There's additional analysis that needs to take place in that situation. So we're going to talk about both of these in turn. First, let's talk about community amenities. And I wish we were in person, because Adam and I have done this presentation before, and we had some pretty good volleys with our pickleball paddles and pickleballs. So I'm going to start with pickleball courts. It's a very popular thing happening right now in communities. There's a lot of communities that I know of that are actually converting their tennis courts to pickleball courts, because nobody wants them as tennis courts anymore. They want to play pickleball. That can cause some sort of concern. Adam mentioned earlier today, and this case that we have referenced here, it's not from North or South Carolina, but it is another interesting case that we found in this community, Sandy River and Cape Shores Homeowners Association. They had tennis courts originally, and if you've ever played tennis or pickleball, pickleball is a lot louder than tennis. The rackets are different, the balls are different, the players are different. And so what happened when they converted these courts from tennis courts to pickleball courts is the neighbors in the vicinity of the courts started complaining about the use of those pickleball courts. They were using them later. It was much louder noise that was happening. And so the court did an analysis of, is this a nuisance? They bought next to a tennis court. It wasn't loud and annoying at that point in time, and the association then changed the use of that property. So it's an interesting analysis that goes on. It's something the associations need to think about when you're considering making a change to common amenities, how that will impact the neighbors that live close by, and what the association can and can't do to lessen that impact. Can you put a time limit on when the play has to stop? Do you have lights on the courts? Do you not have lights on the courts? Can you erect some trees around the courts to kind of help deal with the noise? All of those things are things that an association needs to think about if you're considering converting one of your amenities into something else. Other amenities that we deal often with in community associations, basketball courts. We hear complaints quite a bit about the basketball court. Dog parks where the dogs are running around, that could impact either noise and or smell, depending on what's happening. Pools are big ones as well. Are people bringing their speakers to play at the pool? Is it really loud? Outdoor grilling areas, that one is impacted quite a bit with the smells and sometimes the varmints, if they're not cleaning up after themselves. Outdoor fire pits and playgrounds. all of those common amenities are magnets for claims regarding nuisances. So really important for an association to think about what can you do, and Adam will talk about this in a minute, to help lessen the impact or possibility that somebody's going to come in and use one of those amenities and cause a nuisance to either somebody else or a neighbor who is nearby. So very important to be thinking about that. A lot of times in the community association context, you are already in the community and those amenities are already in place when you buy into that community. But again, it comes into play if you're thinking about changing the use of one of those amenities or making some sort of change that's gonna maybe give rise to some sort of nuisance claim. So it's important to think about that, talk through that with your attorney before you take any action for those. For owner conduct, we're kind of gonna the list is pretty much the same. They're just some smaller actions that just happen on an owner's property, but lots of owners we hear parking is a huge complaint. Fire pits that they may have on their lot, cooking stations or an outdoor grill. I see it a lot in a townhome community. Pools, private pools on lots, pets, parties, landscaping, and play equipment. So the big ones right here, how do those things, when you're reviewing architectural requests, what can you do? Can you require screening to help lessen the impact on those neighbors? All of those things you want to keep in mind.
So as Cynthia is saying, some of the amenities, right, community amenities can blend over and also be lot owner amenities, right? Sometimes you have a community pool and then sometimes individual lot owners have pools, right? You have to be careful when you're trying to say that a pool is a nuisance because kids use pools, right? And families with kids 18 and under living at home are protected under the Fair Housing Act. That's a national law, that's a federal law. And so we have to think about these things, right? So Cynthia and I also work with developer clients, right? The best place to start is to never get in the nuisance business to begin with, okay? So let's start with, we're going to create this community. And so developers, show us your lawyer where you're going to have amenities. And I don't know about you, Cynthia, but I can't stand it when a developer gives me a map and it just says amenity area on it. I need a little more specifics, right? What are we doing?
I want the marketing materials. I want to see all of it.
Exactly. And then because you want to see where they're going to be, you want to see how close the houses are going to be. Where's the multifamily to the single family, to the pool, to the pickleball courts, to the clubhouse, if there's an outdoor grilling area, et cetera, et cetera. So we want to review those site plans and we want to address those potential issues right in the declaration. So we want to talk about how the developer is going to build these things, or they're going to be located here, or some language that says any community amenity shall be deemed not to be a nuisance as long as it's reasonably used, et cetera, et cetera. The next step is dealing with how to address behavior that you don't want in the community. I've been practicing long enough that I have seen declarations where a developer literally took scissors, cut parts out of other declarations, used Scotch tape, and photocopied them rather than have them typed, and so it's a hodgepodge. And so let's empower the association properly, not with a hodgepodge, not a patchwork quilt. Let's be deliberate. What kind of community is this? Is it a 55 and over? Is it multifamily? Are we looking, are the homes garden homes, right? For people that don't really have kids? Or is this a robust community where we're having 5, 6, 7 bedroom homes for people that presumably have families, larger families, may have kids, grandkids, whatever. But you got to provide the language in the declaration from Jump Street to let you know what kind of behavior is and is not okay. All right. The most important piece of that is to give the association what? To give the ability to adopt reasonable rules and regulations to address behavior before it becomes a nuisance, right? We don't want to defend a nuisance lawsuit. We don't want to defend a lawsuit where we're being sued for failing to enforce the declaration. Community manager does not want to have to be getting involved in neighbor versus neighbor disputes, but if the documents aren't drafted well, that's where we're going to be. Providing tools to deal with it, right? What is a tool? It's a fine. That's a tool. A suspension of privileges, that's a tool, right? Towing a car that's parked on a private street, that's a tool. Be careful of the all-inclusive nuisance clause. It's a trap, right? The reason that a nuisance clause is a trap is, what did we say? In North and South Carolina, courts defer to the free and fair use of property. So they want a landowner to be able to use their property how they want. They will enforce narrowly tailored restrictions, which is what we're talking about on this slide. But if you have a non-narrowly tailored restriction, that is a nuisance restriction that is subjective to the interpretation and the whims of whatever board without definition, then a court is likely not going to enforce it. And at worst, they might strike it down.
Well, and I think it's really important, Adam, to make sure that you know what your documents say. I would be willing to bet you that pretty much all of the declarations in both North and South Carolina have that broad nuisance language. No one shall do anything on their lot which causes a nuisance or annoyance to a neighbor. Okay, we all have that in our documents, but what Adam's saying is that alone is not going to be sufficient. And I can't tell you the number of times I have clients come to me when they're dealing with a nuisance situation, and that's their sword that they're using to enforce and try and do a fine or some kind of suspension with owners. And it's hard to give that news to them that language is not sufficient. You need something more. So if something's going on, try and tie it to something that is in the document specifically addressing that situation, or maybe amend your documents to add something to deal with it.
Great example of that is you have someone parking on the grass in their front yard, but there is no restriction that says cars may only be parked on a paved section of a lot or a gravel lot. So your declaration doesn't empower you to stop them from parking on the grass. But the board president says, well, that's a nuisance. Parking on the grass is a nuisance. I got news for you. No, it's not. It's not a nuisance. If you don't want people parking in the grass, then amend your declaration and put in provisions that prevent that behavior, because if you try to fight that as a nuisance, you're going to lose.
Let's talk about sample language.
Oh, well, the sample language, we know it's really small. It's going to be hard for you to see it. Ben and the CAMS team are going to have this presentation available. We've provided to them a copy of the PowerPoint. But these are some nice samples, if you will, of language that targets behavior that some would consider a nuisance without really using the term nuisance, right? So it's like, what are we going to say? I'm going to just read number one. Any activity which tends to cause an unclean, unhealth, or unsafe condition to exist outside of the enclosed structure of their lot. That's pretty broad, but it's not as broad as nuisance, right? We're narrowly tailoring to unclean, unhealthy, or unsafe. Okay. And so there's nowhere in there that says nuisance. The next one, any activity which emits a foul or obnoxious odor, fumes, dust, smoke, or pollution outside of the dwelling, which creates a noise, unreasonable risk of fire, explosion, or other conditions. Now here's our word nuisance, right? But we've narrowly tailored what are the things that are considered to be a nuisance. Those are the types of rules or declaration restrictions that will be enforced by a court. So the rest of them you can just have fun with. I left pets in there, number 10. So how to navigate nuisance on a common area after the creation, right? What did we just say about 5 minutes ago? Best thing to do is to avoid the nuisances altogether by good drafting, good planning of the community, right? Trying to make it to project, if you will, the future use of the property and put the association in a position where there's not going to be nuisance, but if there is, we're not going to call it nuisance. It's just behavior. We're going to take care of it. So what happens after the community is created, right? We've talked about this several times. Was the amenity there before they built the home? Was it in the sales flyer, right? Did they say that we were going to build this, or was there a reasonable expectation that you could have a pickleball court in your backyard, right? If it is, then you're not going to have it. Does the association have that ability to adopt reasonable rules and regulations to address behavior, not necessarily on the lot owner's property, but on the common area, right? Can they say, these are the hours of operation, right, for the pool? And during summer months, you're probably going to have the pool open a lot more than you are in the early spring or the early fall if you keep your pool open, right? It stands to reason that it's reasonable to have a pool open later on a Friday and Saturday night than it is on a Sunday or Monday in May until school is out for the summer, right? But people work even if kids are out of school. And then enforcement in your governing documents.
Adam, I just want to point out here, this seems silly to point this out, but I will say I have had clients who have the authority to adopt the reasonable pool rules and regulations, but they haven't actually adopted them. So it seems silly for me to say that, but when they come to me and say this is a nuisance, we can adopt a rule about this. We want to find this person because they're doing this activity. If you haven't actually adopted the rule saying they can't do it, that's step number one. So if you don't have those rules, make sure you are getting those in place to deal with some of the things you're seeing about your community. Not just that the board can do it, but have they actually done it? And then review them annually. You might have new things coming up all the time. If you don't take a regular review of those rules that you've adopted, you're not going to realize what needs to change and be updated. So make sure you're doing something like that annually, and CAMS can help you with that.
And be careful. At law in North and South Carolina, the members don't vote on the rules. The board adopts the rules. And the moment they're adopted at a meeting, they're enforced. But your governing documents, we've seen it in both North and South Carolina, can say that the rules are not effective until they are mailed or until they are posted or until they're sent to the members or likewise. So just pay attention. Pay attention to what your governing documents say.
So when you're looking at amenities, either putting in new amenities, because I have clients do that from time to time, or changing the use of one of your amenities, what are things that you should be thinking about as a board to see if it will maybe cause some concern regarding a nuisance? Is it going to be something that's loud? Is it going to create smells and odors? When will it be used? What are the hours of operation? Like Adam said, be thoughtful about it. The summer hours of operation might be very different than the winter. The weekend hours might be very different than during the week. The lights, are you going to use them? How are they going to be pointed? Is there a time that they have to be off? How close is the amenity to homes, and how will it impact those neighbors? And what can you do to lessen that impact? What type of proactive steps can the association take to make the amenity use a little bit more reasonable so you avoid any claims of having a nuisance on that property? So those are all things you want to be thinking about when you're using your amenities or making a change to those amenities. With owner actions, you know, if you're on an architectural committee, please think about these things. When you're adopting your architectural guidelines, think about these things when you're approving them in the community. What's the location of the item going to be? Are you going to allow lights? Are you going to restrict the hours that somebody can do something? Where are you going to have parking? Like Adam said, if the documents aren't clear, you may not be able to do anything about somebody parking in the grass. Look at your documents to see, do your documents also give the board the authority to adopt rules regarding owners and what they can do on their lots? They might do that. So make sure you're looking at those documents to see how can you help and what are you considering when you're reviewing the architectural applications for your owners within the community, so you don't have the neighbors start complaining about a possible nuisance because you allowed the pool and the pool pump's right next to your window and now it's keeping you up at all hours of the night.
So when, that it is telling, right? Because a lot of in close knit communities, right, where they're on top of each other, especially like Cynthia said with a pool pump, we have seen where a pool pump that is literally a foot away from someone's bedroom from one house to the other can be a nuisance. Maybe we ought to think about that if we're on the architecture review committee, that maybe we're going to ask them where they're going to put the pump, and we want the pump put in the backyard or not on the side of the house, right? Where is the flow, the backwash flow going to go from the pool, right? When we drain it, is it going onto common area? Is it going onto a neighbor's house? These are all things we have to do. So like all things, we begin at the end, right? Not at the beginning. But when someone is claiming that behavior by their neighbor is causing them consternation, the first thing to do is figure out, did they get proper approval for whatever it is they were going to do, right? I mentioned no scaping earlier, right? That type of landscaping, is it okay? And so if they just did it without approval and it's an eyesore, right? It's a site type thing. Let's check and see if they did that. What about the behavior they're engaging in? Is that a violation of the governing documents? You saw in the previous slide, it mentioned quiet hours. Well, guess what? Quiet hours can only really be adopted if you're allowed to adopt them in your governing documents. You might be able to adopt them for a condominium building, but maybe not for a single family community. But the other thing about it is, what is a quiet hour anyway? Unless you're going to measure the decibels or you're going to have it limited, how are you going to determine? It can't just be like what the Supreme Court said in, the Larry Flint cases, like pornography. I can't define it, but I know it when I see it. That does not fly when we're dealing with restrictive covenants. And so the other thing is, can the association help the person mitigate it with their neighbor? And I take a big pause and a big sigh, right? Because one of the challenges of both a manager and an attorney in a community association space is that a lot of folks believe incorrectly that the association is there to solve all their problems, including if they don't like their neighbors, or that they don't want to actually ask their neighbor to stop doing something. They'll come to the association first. So yeah, you could step in, but the other thing is, should you, right? Is that the association's role? What is the association's job? Is it to mitigate these things or is it not? Most of the time, it's probably not. And so, finally, look and see if the behavior is a nuisance, right? We read a couple samples about obnoxious smells, smoke, and this and that. If somebody's grilling pigs with a giant pig cooker every weekend for 36 hours straight and the smoke is blowing into your backyard, that might be a nuisance, right? So maybe we talk to them and say, hey, can you just cook one pig one day a week instead of every day? I don't know. I mean, I love barbecue. I mean, obviously I'm a big guy. I don't miss many meals.
I love this slide. I'm just going to say, because we're going to talk about one of our favorite cases. It's in North Carolina, but we're infamous for this case all across the country, right, Adam?
We are. This is, if you haven't heard of the Steiner versus Windrow Estates, it's the Nigerian dwarf goat case. All right. And Cynthia's law firm, although I will say she was not a member of the firm at the time. And so she has clean hands. This was an equestrian community in North Carolina where Miss Steiner was battling cancer. And she took two Nigerian dwarf goats. Their names were Fred and Barney. Apparently, she liked some Hanna-Barbera cartoons. And they were her companions. And she picked them because Nigerian dwarf goats are very good around horses. They don't startle them. This is an equestrian community. She had little goat houses for them. She knitted sweaters for them. She walked them on leashes. They were neutered. They had their horns removed. But some people in the neighborhood didn't like that she had goats, and there was a provision in the covenants that said no livestock. Well, the court said, no, these are pets, they're not livestock. But the lawyer for the association said, aha, who cares if they're livestock or not? They are a nuisance and they violate this noxious, offensive activity. We got you dead to rights. Fred and Barney are going to the meat factory. Well, guess what? The court said, no, this provision is void for vagueness because it was too subjective. And so not only did Ms. Steiner get to keep Fred and Barney, but the association lost its nuisance provision.
And all associations lost their nuisance provisions.
That's right. And so it gave lawyers, at least in North Carolina, a lot of work because we were drafting amendments to covenants on the regular. But this is the horror story, and this didn't just happen in North Carolina. There is not a case in South Carolina on this, but there are cases in about 30 other states that have done this same thing.
And that's the language we're talking about. That's why if you're dealing with the situation you think is a nuisance, this is not the clause you should be relying on. Look in your document, see if there's something else. And if not, and it's a big enough problem that you need to address, then talk to your attorney about options and what amendment can you maybe consider and put forward with your membership, or could you adopt a rule to address the situation? You are not going to be able to rely on this broad language regarding nuisances.
So before we get to the questions, the first thing you're going to do let's just say you're new on a board, right? One of the things that you can do if you've been having troubles with neighbor versus neighbor stuff is try to identify opportunities for the association to adopt those rules and regulations over the use of the common area to alleviate nuisance. If people are playing pickleball till 10 o'clock at night, make it 9 o'clock at night. Get rid of the lights, make it dawn till dusk, like a pool that doesn't have lights, right? Make sure that you have remedies if there's nuisance activity without calling it a nuisance, right? Make sure that you're fining people or you're taking away their privileges. And it's really hard to suspend somebody's privileges from a pool if it's an unattended pool, right? Oh, they shut their key fob off. Well, that's great. They're just going to borrow their neighbor's key fob, right? So just be mindful about these things. And then the other thing about, it's just like nuisances are like, bad news. It doesn't keep very, very well, right? You need to deal with it quickly. Otherwise it'll fester and it'll start to rot. So you got to nip it quickly before the emotions get too evolved into it. So Ben,
Okay.
well, we got some time here. We're doing well.
Well, excellent. Thank you for running us through that. Something I thought y'all might want to touch on is the difference between adopting rules and architectural guidelines, because a lot of people use ARC guidelines and at least ARC enforceability to a rule that governs someone's use of their lot. Can you clarify that?
Happy to. When it comes to architectural guidelines, at baseline, an association does not have the ability to adopt any architectural guidelines. You have to look in the declaration to see if there is the ability to adopt them and if you're even going to have an architectural review committee. That said, it's based typically on aesthetics. That is what the building is going to look like for new construction or modifications to construction. It is generally an overreach to put anything in there about behavior outside of the time that construction is going on, right? So it's one thing to say, you can have a porta-john on the property during the time of construction as an architectural guideline versus an outhouse after construction, right? Or, hey, your dog, you got to keep your dog on your property. That's not an architectural guideline. Telling someone they have to keep bikes in a garage or scooters in a garage, that's not an architectural guideline. That's a rule or regulation. So you have to remember that the authority in the ARC, right, the architectural guidelines, comes from the declaration. It may only let you pick the paint color. It may have you pick the building material, right? It may be the pitch of the roof. It might be the height of the home. These are all the types of things that are architectural guidelines, not somebody's necessarily the color of their blinds or shutters inside their house.
Yeah, and it's a good point, Ben, because I see all the time architectural guidelines that probably were drafted originally by the developer, is my guess, or the first board, that contain a lot of specific things in them that are not architectural matters. They're talking about where you can park your car on the lot, what action you can and can't take on your property. That's not, like Adam said, that's not architectural. That's going to be a rule and restriction, something completely separate. And unfortunately, we have to give bad news a lot of time when they try and use one of those provisions and they really didn't have authority to adopt it because it's not an architectural guideline. So you have to be really careful to make sure when you're adopting those guidelines, you're doing them within the boundaries that are set out in that declaration. So you're not overreaching. You've got to have specific authority for the things you're adopting, whether it's a rule or an architectural guideline, and they shouldn't bleed over into each other.
Okay. First question, I think we have a whole webinar on this topic. If not, we might need to update it. But how should a board handle complaints made on social media? And can social media be a nuisance?
The answer is, yeah, the answer is no, social media can't, right? It's not projecting something onto your property. It's not an odor coming onto your property, right? It's not a noise coming onto your property. So social media is not a viable claim for someone throwing shade at you or opinion. When we talk about social media, it's speech. Speech is protected in the United States. It's protected in North and South Carolina pretty zealously. So the only type of speech that's not going to be protected is defamatory speech. Defamatory speech really rises to the level of someone saying something false about you that is other than an opinion. So I'm going to give you an example. Someone can say you're an a-hole and you're the worst person in the world and that they wish that you'd move out of the neighborhood. Nothing you can do about that. That's not defamatory. Is it mean? Yeah, but it's not actionable. Now, if someone says, hey, did you know that Cynthia Jones has a rap sheet as long as my arm? She's a petty criminal, stealing mailbox flags from her previous neighborhood. And that's not true. That's defamation because I've called her a criminal. Now, if she is a criminal and she was convicted of those things, then that's perfectly fine too. But the best policy on social media, in my opinion, and Cynthia, I'd like you to chime in, we actually create for our boards a policy that the board members agree not to use social media. That is not to respond, not to get on it, not to get on Facebook, not to have a community Facebook, not to get on Nextdoor, but to use the official website of the community only for communication and to stay off and not post anything.
Yeah, no, I agree with that 100%. I have a love-hate relationship with social media. It is very, very easy for people to post and say things that they would never say to somebody else's face because they're behind this shield of social media, and it can be very troublesome. I don't want my boards on it. I don't want them to host a Facebook page. And I'll tell you something else. When you're on it, if I'm Cynthia Jones and I'm on the board, and I try and make the argument that I'm commenting not as a board member, but as Cynthia Jones, that doesn't work. Everybody knows you're a board member. If you start engaging in those, they're going to take that as association action. And that's a very quick way for you to get in trouble, depending on the situation, pretty big trouble with discrimination and things like that. So I would use it extremely cautiously if you use it. Definitely, if you're using it, you have to have a policy in place for your board members and for the use of those social media websites. Talk to your attorney about that. It's extremely important. We prefer you don't use it, but we know that this day and age, many people are on it. So if you want to use it, please have that discussion and get those tools put in place before you do it.
Okay, back to one of the earlier slides about sight. Can sight lines to a lake or golf course be deemed, I guess the blocking of those sight lines to a lake or golf course be deemed as a nuisance?
That's not nuisance behavior, right? Because that's enough, that may or may not be actionable, but it's not under the claim of nuisance, right? So whether or not you have a sight line, right, which is an actual interest in real property over someone else's, that's actually an easement. Is that recorded with the property that you own? We see it. We represent a lot of mountain communities, and there will be reserved sight lines for each of the homes so that you can't build within those. But no, that's not, and also like putting up vegetation, it's a spite fence. It's not a nuisance, right? It can be a spite fence, which is a different type of action in North Carolina, but blocking somebody's, they may have the right to block it, they may not. It's a case by case basis,
But not a nuisance one.
not a nuisance.
Okay, I'm going to paraphrase the next question, but a beach community with rowdy vacationers that alternate from property to property. These vacationers in different units from time to time make a lot of different noises. Is there a way to penalize those individuals that may not be, consistent across units? And is there anything to do with the rental company? And is there a remedy that you can offer?
Well, first of all, the association has no right to do anything to renters. The only action it can take is against owners, right? And so if the behavior of the renter is a violation of the covenants, then you can fine the owners. But what I will tell you is that beach properties, beach rentals, especially during the busy season, are quite lucrative. And we have many that will gladly take $100 a day fine for their rowdy, tenants because they're getting $1,200 a week or whatever. They don't, or $1,200 a day for a big house. I mean, so the answer is there's nothing that you can do with that, unless you make it uncomfortable in terms of the number of fines that you do. But it's Cynthia, this is one of those where it's like, case by case, but it's just tough because people on vacation, they want to have fun.
I mean, I want to have fun when I'm on vacation, but I mean, it also comes down to like, what are your, and my lawyerly answer here is it depends. What do your documents say? And what are they doing that you think is a violation of those documents? Is it so bad that the noise level is so high and you have restrictions on that in your documents that you can enforce it against the owner? Maybe, maybe not. I'm with you. I've had situations where I have an owner who's happy to pay $100 a day to keep those people on the property, and they don't really care about it. And that's pretty difficult to deal with. It depends on the situation. It depends on what your documents say.
Okay, I know we're slightly over in time. We started a few minutes late, but y'all are good continuing on for a little bit. Okay, if you do need to drop, please feel free to drop off, but we'll get through a couple of questions coming. So with the increase of house mood lighting, I guess the LED lights that are popping up from time to time, could you determine those as a nuisance?
Ooh. I've actually had this in a community where somebody took those strips of LED lights and put them all over the front of their front porch. They were not getting along with their neighbors. They did many things, but that was one of the things, and then left them on all night. It was very, very bright. So everyone knew who they were very quickly. I mean, again, yes, it could be considered a nuisance. We talked about that, the site nuisance and the lights. Are they allowed to have them? Do they have to turn them off at a certain time? Where are they shining? Is there a limit on how long they can be up? Lots of times during the holidays, we have those kinds of limits. May not necessarily have prohibitions against lights the rest of the time. Really comes down to what do your documents say and what action are they taking that's causing that problem.
Yeah,
Okay.
I've not had that, but I agree with Cynthia. I think that it could be, and it might be that they didn't get permission to put them up. And maybe if you agree to let them have them, then you require them to shut them off at a certain time as a condition.
Okay, I'm going to shorten this next question a little bit, but it's all about grass and weeds. Our documents restrict grass height to 5 inches, but it doesn't say anything about weeds. Our docs say something about a pleasing appearance, but we haven't sent any violations. Is there anything that we can use to define what is grass and what is a weed?
Well,
I
you're gonna need to amend your documents to do any of it. I had a case in Emerald Isle, North Carolina, where we had somebody that wasn't keeping up their grass, right? They weren't fertilizing. It was a lot of weeds than grass. We said that it was an unkept front yard. We lost. The court struck our nuisance clause, and we had to go back and amend. And the owners were happy to amend and make it very specific. And we included a provision where it had to be treated twice a year with, pesticides, and weed free. And so that's what you have to do. When it comes to any definition, if it's not in your declaration, a court will look at the dictionary definition. It's what's called the ordinary meaning. And so, good luck with that one, because that's going to cost you mightily to fight about that in court. Better to just amend your document and define what it is.
Well, and let me point out too, Adam, I know you do the same as I. We deal with this every day because there are numerous files that come across my desk every day where an association's wanting to hold an owner in violation of, this is a great example. There's weeds on the property, and so it looks unkempt. And our restriction only talks about grass height. I'm amazed it talks about grass height. Most of them don't talk about grass at all. What can we do about it? And the bad news I have to give them is you can't do anything about it unless it's something that's specifically dealt with in your documents. If it's not, you need to amend to get it in there, or you can't hold them to a hearing and you cannot fine them. So we see it all the time with things like grass, weeds, power washing the side of the house because there's mold and mildew there. I mean, weekly I get these, mostly for liens, where we're reviewing the fines on the account and we have to give some very bad news and say that's not something you can fine them for. So be very careful when you're working with your manager on these violations. Make sure you're looking at your documents, make sure you're quoting the specific section that they're in violation of, and make sure it's specific enough. And if you have a question about it, ask your attorney on the front end. It's a lot better for me to give you that information up front than it is when you've got $5,000 in fines because somebody didn't pressure wash the side of their house.
Okay, noise complaints with children running and jumping in a multi-story building. Is this considered a nuisance, and how can we resolve this?
Well, you got to be careful. It's probably not a nuisance unless it's happening late at night and for a long time. Remember, families with kids 18 and under living at home are protected. So the fact that kids are running and jumping, kids are going to run and jump. Okay. Now, if it's keeping you from sleeping, then maybe it could be a nuisance and it's going on all the time. What I would try to do is I would try to focus on making requirements for noise dampening carpets and other things that when you're in a vertical stack. But it's really hard to target children. You're going to get in trouble with the North Carolina Human Relations Commission if you target children. Cynthia, you got anything you want to throw on that?
Oh, I agree with that completely. Be very, very careful. Please don't adopt a rule that says no kids can be loud in the hallway at night. Just say nobody can can do it. Don't limit it to age. Don't reference children. I think that's going to get it. It's sometimes very well meaning, right? We see it with regards to children under the age of 16 are not allowed to use the pool by themselves. Yes, that's great. That's very well meaning, but it's going to get you in trouble every time. So be very, very careful about it.
Right. And if you're going to adopt quiet hours in a multifamily, have a decibel, explain to the other owners how to make a decibel reader on their phone. so they can, and check with the town ordinance if it's too loud. But I think that the trouble you have sometimes, I'll just give you an example. This was a community in Brunswick County down in Calabash where this lady didn't like kids, and there was a little kid, a little girl, 3-year-old, riding a tricycle in front of her house. She happened to be out in the front watering her lawn, and she used her hose and sprayed the little girl, knocked her off the tricycle. Well, then the dad chased the lady, who was older, she was like 65, into the house, broke down the door, assaulted her, whatever. It was a big, terrible thing, right? It's because she didn't like kids. Well, she should have bought in a 55 and over community where there are no kids. Now, the dad went to jail. She got charged with assault, and it was just a really ugly situation, on a community street. And so just be careful when it involves kids. You got to be thoughtful. Take the kids out of it. Focus on the behavior. What is it? The noise. All right, we want to be quiet. We don't care if it's adults stomping. We don't care if it's dogs, right? Let's address the behavior, not who's doing it.
Yeah. Wow. But so two similar questions, and these are both about people using the nuisance provision and chronically complaining about the neighbors, trying to get the board to take action. How should the board address these individuals that constantly frustrate either their neighbors or their association?
What
Oh, we couldn't hear you.
what did you say?
That never happens, does it?
Never.
No, it happens all the time. And it's, yeah, like Adam mentioned it earlier, there's this thing that happens when people buy in a planned community, where sometimes they think, well, I live in an association, that association's supposed to fix all my problems. Here you are, board, they're creating a nuisance, do something about it, make it stop. And I hear that all the time. Sometimes, depending on what's in the documents and what the nuisance activity is, they may be able to do something about it. And maybe they should. It depends on the certain situation. They may not be able to do anything about it, or it might be one of those situations that truly is a neighbor to neighbor issue that the neighbors are going to have to deal with it. It depends on what the situation is. And if you've got that going on, I would encourage you to talk to your attorney about it and get an opinion about, should the association do something about it, and can they do something about it and help you with that situation? Because it can vary greatly, but sometimes the answer to the owner just is, that's not a violation and it's not something we can do anything about, and they're not going to like it, but sometimes that's what you have to say.
There's two angles to this, right? So people who complain about other people are very annoying, especially if you're the manager, right? And so what we've done is we create what I call a complaint form. So if you want to actually submit a formal complaint, I give you a complaint form, which you have to sign. You have to attach pictures to it. You have to sign, and you have to authorize that your name can be used in the hearing. You have to acknowledge that. If you don't do that, then I'm not going to accept the complaint, right? So that's how you deal with people who like to complain about other people. If there's people that are behaving poorly, but it doesn't rise to the level of a violation of your documents, like Cynthia said, or they're annoying what they do to other people, then there's no association role. Now, I have had associations where they have a problem neighbor who keeps violating the covenants, keeps paying the fines, won't do anything, just continues to be a problem. Those associations, and it's happened a handful in 25 years, we actually have approached those people and bought their house. The associations actually bought their house to get them out of the neighborhood, and they usually have to pay way above market, let me just tell you, to get them to leave. But sometimes it's worth it, right? To get a better neighbor in the community. Not all of us have that, but look, the association, to kind of tie a bow on this, the job of the association is to manage, maintain, repair, and replace common facilities, and to follow the governing documents. If the people are just annoying, but they're following the governing documents, I'm really sorry. We can't all get along. I wish we could. That's why I stay off social media unless I'm tracking my teenagers. That's the only reason I'm on it. I gotta see what they're doing.
Okay, I think you answered this question earlier, but is an auto repair in the driveway in a townhouse a nuisance?
No, it's not going to be a nuisance, but it might be a violation of your documents, right? And so if you don't want somebody to work on a car in their driveway, or you don't want somebody to have a car up on blocks, or it's not going to be a nuisance, but it might be a violation of covenants. And if it's not in there, then amend your covenants so that it is. If you want to get rid of that, if you don't want people doing that.
Okay, and this one too, I think a dog left in a garage daily while an owner is at work. Two large dogs bark almost all day. How should this be handled?
I think that could be a nuisance, depending, right? Depending on proximity. If they're in the garage, multiple homes can hear them and they're barking for 8, 9 hours. There also might be an argument that there's a neglect of those animals, especially if it's not heated or cooled in that garage. So maybe where I would start is with animal control, and not the association calling animal control, by the way, but telling the neighbors that are complaining to call animal control, and they may come out and say, hey, look, we're going to take your animals if you don't treat them better.
Yep, that's absolutely what I would do as well. I'd start with animal control.
Let somebody else do your dirty work. We got enough dirty work we got to do. Let some paid officials, before Doge gets rid of them all.
So our CC&Rs specify a decibel level for sounds coming from a property which can be heard from another. Is that enforceable? And if so, how? Should homeowners or board members use a decibel meter and screenshot the results?
Yes. I mean, it's enforceable. Yeah, it's a covenant, right? I mean, Cynthia's nodding. If it's in there and it says that this is what it is, and you've got screenshots of it, that's the best evidence that you can have, especially if multiple neighbors. Heck yeah, fine them.
Yep.
Fine them for that.
Amazing. You don't see that very often, so I would use it.
Yep. So next, this question, more of a or statement, more of a question, but some noise complaints should be addressed via local ordinances versus the HOA. And so that is exactly what you just said, Adam. Let the police or whomever enforce that. If our association does not allow fishing, boating, or swimming in our retention ponds, can we consider that trespassing or a nuisance?
Well, okay. First of all, it's not, okay, let me just back up. If your covenants say that you can't do these things and people do it, then it's a violation of your covenants, okay? So you can fine them, you can suspend them, right? It's not a trespass because they have easements over, upon, and through the common areas by virtue of being an owner. So do their tenants, their guests, and invitees. So it's not a trespass if they're a member of the community. But you do not need nuisance. You already got what you need.
Yeah.
Okay. Last question, maybe last two questions.
But Ben, let me stop here.
Yep.
But don't listen. If it's a violation of the covenant, you can still go to court and ask a judge to get an injunction to stop the person from doing the behavior that's violating, right? And so we do that with rentals all the time, especially when you have rentals on golf courses, and there's very nice golf courses in Charlotte, down in Myrtle Beach, and where people can rent for a lot of money. They're going to keep renting, but we can get an injunction to prevent them from renting in violation of the restrictions. So if these people are continuing to get into the retention ponds, even though you're fining them, then maybe you want to take them to court and get a temporary restraining order that turns into a permanent injunction. So that way they go to jail if you catch them swimming. And by the way, Cynthia, have you ever heard of someone wanting to swim in a retention pond? Like, I mean,
Yeah, I don't want to fish in there either. No.
I mean, I don't want anything to do with them.
Hopefully it's a nicer pond than a retention pond, but Okay, this could be, I think we do have a couple of webinars on this one, but protocol for inviting and including homeowners in an HOA board meeting. I know this is non-nuisance related, so if you do want to answer or kick that to another session, please, because it could go on for a while.
Look, I will just start with this one. I think it's a great idea to have your owners come to at least a portion of your board meetings or have them open so members can come if they want to. I have found through the years of doing this that when you meet in secret and you don't tell anyone when you're meeting and you don't give them copies of minutes, they think you're doing bad things. You're probably not doing bad things, but that's what they think. Let them come. There's no harm in letting them come hear the discourse that goes on between board members for the matters that you're running for the association. Certainly, if you're talking about things like litigation or collections, you need to do that in executive session without them there. But why not let them come to other portions of your board meeting? They don't get to participate in the discussion, and you should be clear with that. But if there's something they want to say to the board, open up the first 10 minutes of your board meeting to members and make it known that they're allowed to come and speak if they want to. If they want to come and observe the non-executive session portions of the meeting, let them do that. If they're disruptive, ask them to leave. But I think it's always a good practice to let those members come, hear what's happening. I have not seen it really do much harm.
The only thing I'm going to say is there's a core 4 items that should never be discussed in front of the members. Personnel matters. If you have employees of your association, those should never be in open session. Anytime you're negotiating contracts and you're talking about different bids, should never be in front of anyone because you don't want a tortious interference with contract claims. When you're meeting with the attorney, talking about litigation, or anytime you're suspending someone or putting a lien or collections efforts. Those are your core 4. The rest of it, as Cynthia said, it's called the open session. Doesn't mean they get to talk the whole time, but they can come and see how the sausage is made. Maybe they'll feel a lot better. Maybe they'll feel a lot worse. But I would caution you, I don't like to let members attend virtually. Because if members attend virtually, then you can't stop them from recording your board meetings because they can record it on their phone and you don't know that they're doing it and it'll come back and get you. I promise you, it will bite you down the road. People that record things clandestinely or otherwise, it ain't for good, folks. Let me tell you, they have bad intentions. They're coming for you.
Okay, last question. And this gets into maybe what you were saying about contracts, but do you recommend sharing contracts and or the CAMS contract with homeowners? And I know North Carolina has some wonderful legislation that's been proposed that discusses that. So thoughts?
Cynthia, do you want to go first or do you want to have the last word on this?
No, I mean, I don't want the last word. It depends, right? If you've got a contract that has a confidentiality provision in it, definitely you shouldn't be sharing that, or you should get permission before you do it. I think there's an argument. We don't have any cases on point that I know of in either state with regards to nonprofits, but in North Carolina, I know we do have some business cases that say the underlying contract really goes to the financials of the organization. So a member should be able to see a copy of that contract. I don't just readily hand them over. I look at the request, I see what it's for. I check a confidentiality provision. I might even do redactions to it. But there are circumstances where I give them to owners if they're asking for it and they have a legitimate purpose.
Yeah, I will. I take a stronger stance against them. I don't like giving them out. And obviously Cynthia is cautioning you in any contract. Make sure you got to review it to see if there's a confidentiality clause. Because let's, for example, say you have a homeowner that comes and wants a copy of the CAMS contract and there's confidentiality in it. I'll say as the board president, yeah, you can have it. You just have to call Ben Rhodes and ask him for permission. If Ben gives you permission, then you can have it. They're never going to call Ben. I promise you, they're not going to, right? But if I am going to give it, right, I am going to redact. And redaction, as Cynthia pointed out, is I'm going to remove the pricing. I'm going to remove the schedule. Because what I don't want to do is I don't want them nitpicking and I don't want them taking it to competitors. That's not what we need members doing. It erodes the purposes of the board. If you want to see what services the management company is providing, then fine, right? You know how much it costs because you see it on the annual budget. You know how much the contract is. You don't need to see it broken out. And it drives me crazy, backseat drivers for any contract, right? I love it when we get a request. Oh, we want to see all the legal bills. Well, you know what? The legal bills have attorney-client privilege information in them, right? I don't mind sharing with you how much the association has spent, but I can't show you what we worked on for the association because it's privileged information. You're not entitled to it. Only the board can waive attorney-client privilege. And please don't, because as a lawyer who has been deposed, because I've had clients foolishly do that, you don't want your lawyer to become a witness against you. It's not a good place to be.
And please, like, if you get a request, we know how this is going to happen, right? You've got an owner who's upset about something. They get ticked off with the association. What are they going to do? They're going to fire off a 3-page letter that lists 50 things they want the association to turn over to them. Please don't, as board members, don't just hand it over. Talk to your manager at CAMS, talk to your legal counsel, make sure you're doing an evaluation because there's some things they're not entitled to get as members. They would have to be a board member to get it. So before you just hand things over, make sure you talk to your manager, make sure you talk to your legal counsel, do an analysis of what it is they're asking for, why they want it, and whether or not you can turn it over. If you just hand it over, it's going to be too late and you're going to be in a bad situation like Adam was talking about.
Yeah, I mean, find out why they want it, right? What's going on? Well, they didn't trim my bushes the way they did. They're not, CAMS isn't patrolling the neighborhood as much, right? They're in breach of their contract. I want you to cancel their contract. Not helpful. Not helpful. You want to be involved in your community. I'd say to any of the 21 of you remaining on this call, run for your board. No, seriously, you want to be an agent of change, run for your board and get an appreciation of how challenging and difficult it is to be in that seat and to have everybody pointing their ire at you for every little thing. And then put yourself in the shoes of the manager who's supposed to solve all those problems. And when they have trouble, they call us. Whew. I mean, it's a tough, but look, every situation's different, right? And we've been doing, I mean, Cynthia and I together have been doing this for, 40 years, right? And I see something new every week, and so does Cynthia. And we love helping our communities and we love navigating new things. But some things like nuisance will be around long after we're retired and we're here long before we were, started practicing. So it's just trying to find those good solutions, right? That get you where you want to be, which is make people happy.
Okay. Well, with that, thank you very much, Cynthia, Adam, everyone that's with us. Just a reminder, we'll post this probably by Monday of next week on the camsmgt.com website. So please share this information with your other board members. So thank you again and good night.
Thank you.
Have a nice long
Okay.
weekend, everybody.
We'll see ya. Bye-bye.
Bye-bye.